Hello and welcome to Employment Law for Management. Happy Healthy Employment Management Group and myself, Mary Ann, would like to welcome you to today's training. Objectives of Management Training on Employment Law presentation. Recognize state and federal laws regarding employee issues and rights, spotting workplace issues, promote and maintain a diverse, comfortable, productive, and safe work environment. How to address and work through the issues, how to handle a violation of employment law. Employment law. Your responsibility as a manager. How you can make a difference knowing the laws that apply to your reporting employees and creating a safe and secure work environment. Why listening to employees working under you creates a better environment. How applying the law makes a difference. What are the implications for not following the laws? Discrimination and harassment. Laws for protection against harassment and discrimination. Discrimination. Title VII of the Civil Rights Act of 1964 protects employees and job applicants from employment discrimination based on race, color, religion, sex, and national origin. Title VII protection covers the full spectrum of employment decisions, including recruitment, selections, terminations, and other decisions concerning terms and conditions of employment. The Age Discrimination Employment Act of 1967 protects certain applicants aged 40 years of age and older from discrimination on the basis of age in hiring, promotion, discharge, compensation, or terms, conditions, or privileges of employment. Americans with Disabilities Act of 1990. Title I of the ADA protects rights and responsibilities of the employees and the job seekers. It protects from discrimination against qualified individuals with disabilities in applying for jobs, hiring, firing, and job training. Discrimination. Americans Act of 1990 continued. This includes by failing to provide a reasonable accommodation that would permit the employee to perform their core job duties. Accommodations include no-tech, low-tech, high-tech, reassigning work, job restructuring, flexible leave policies, modification of equipment and devices. The National Labor Relations Act protects the employee's rights to get together to discuss or try to improve working conditions. Even if the employee does not belong to a union, they qualify for these rights. Harassment. Workplace harassment is a form of discrimination that violates Title VII of the Civil Rights Act and other federal regulations, including age discriminations in the Employment Act of 1967 and the Americans with Disabilities Act of 1990. When does it become unlawful harassment? When the employee must endure offensive conduct and it becomes a prerequisite to continued employment, or the conduct is severe or pervasive enough that a reasonable person would consider the workplace intimidating, hostile, or abusive. Also, if a supervisor's harassment results in an obvious change in the employee's salary or status, this conduct would be considered unlawful workplace harassment. What are protective statuses? Sex includes pregnancy, sexual orientation, or gender identity. Race, color, creed, national origin. Age, disability, religion, genetic information. Harassment is not just sexual. Harassment is any behavior that is unwanted or discriminatory in nature. How to handle harassment or discrimination. If you as a manager witness harassment or discrimination, it is your responsibility to step in. Address the issue immediately and report it to Human Resources as well as your supervisor. If it is your supervisor, report it above them. The legal and monetary consequences of discrimination and harassment cost companies millions of dollars each year. Protect your company and report harassment and discrimination ethically. Employee lawsuits are expensive. An average cost of court settlement is about $40,000. In addition, 10% of wrongful termination and discrimination cases result in $1 million settlements. Most cases, about 67%, are ruled in the plaintiff's favor when taken to litigation. 1 in 5 Americans has left a job in the past 5 years due to a toxic workplace culture. This turnaround costs an employer over an estimated $223 billion during that time for those 1 in 5 who've left their jobs. 49% of American workers have thought about leaving their current organization, while nearly 1 in 5 have left a job due to a toxic workplace culture in the past 5 years. 76% of American workers said their managers set the culture, yet 36% said their managers did not know how to lead a team. It's your responsibility to lead this team and to keep your employees happy and healthy. 26% of American workers said they dreaded going to work. Do you think that 26% was able to give 100% in the workplace? Federal labor law standards covers compensation, overtime, child labor, minimum wage. Minimum wage is $7.25 per hour. Many states also have a minimum wage law that is different. Some states' laws provide greater employee protections. Employers must comply with both. Your FLSA poster must always be displayed. Overtime pay. Unless exempt, employees covered by the Act must receive overtime pay for hours worked over 40 hours in a work week at a rate less than 1.5 times their regular pay. There is no limit in the Act on the number of hours employees aged 16 and older may work in a work week. Equal Pay Act requires equal pay for equal work. A federal law, the Equal Pay Act, requires employers to pay men and women equally for doing the same work. Child labor. The child labor provisions authorized by the Fair Labor Standards Act of 1938, also known as child labor laws, were enacted to ensure that when young people work, the work is safe and does not jeopardize their health, well-being, or educational opportunities. Protected leave laws. Family Medical Leave Act. The FMLA provides certain employees with up to 12 weeks of unpaid protected leave per year. It also requires that their group health benefits be maintained during the leave. FMLA is designed to help employees balance their work and their family responsibilities by allowing them to take reasonable unpaid leave for certain family and medical reasons. It also seeks to accommodate the legitimate interest of employers and promote equal employment opportunities for men and women. FMLA qualifying events are for the birth and care of a newborn child of an employee, for placement with the employee of a child for adoption or for foster care, to care for an immediate family member such as spouse, child, or parent with a serious health condition, to take medical leave when the employee is unable to work due to a serious health condition. Time taken off work due to pregnancy complications can be counted against the 12 Weeks of Family Medical Leave Act as well. Protected leave laws continued. USERRA is a federal statute that protects service members and veterans' civil employment rights. Among other things, under certain conditions, USERRA requires employers to put individuals back to work in their civilian jobs after military service. USERRA also protects service members from discrimination in the workplace based on their military service or affiliation. FMLA exigency leave, short-term notice deployment, military events, related activities, child care and school activities, financial and legal arrangements, counseling, and post-deployment activities also qualify as family medical leave acts. OSHA, the Occupational Health and Safety Act. With the Occupational Safety and Health Act of 1970, Congress created the Occupational Health and Health Administration to ensure safe and healthy working conditions for men and women by setting and enforcing standards and by providing training, outreach, education, and assistance. To assure safe and healthy working conditions for women and men by authorizing enforcement of the standards developed under the Act, by assisting and encouraging the states in their efforts to assure safe and healthful working conditions, by providing for research, information, education, and training in the field of occupation safety and health, and for other purposes. Safety training. One key component of OSHA compliance is providing employees with adequate safety training. Training in the safe way for workers to do their jobs well is an investment that will pay back over time, over again in fewer injuries and illness, better morale, lower insurance premiums, and more. Training plans should include information about what to do in emergency situations, what to do if an inspector visits the workplace, and how to handle hazardous substances and/or blood-borne pathogens. Record keeping. As soon as any safety incident takes place, be sure to complete an injury and illness incident report and log it in the overall OSHA form. The document can help your company perform workplace safety evaluations, identify repeated hazards, and create additional safety precautions. It can also be useful should you ever need records for safety investigations or claims. Reporting. In certain cases that require more immediate reporting to OSHA, Any workplace fatality must be reported to OSHA within 8 hours. Any hospitalization, amputation, or eye loss must be reported within 24 hours. Certain OSHA standards apply across all industries. Requirements for all sectors of industry are those that address access to medical and exposure records, personal protective equipment, and hazard communication. Federal OSHA standards. Access to medical and exposure records. This regulation provides a right of access to employees, their designated representatives, and OSHA to relevant medical records, including records related to the employee's exposure to toxic substances. Personal protective equipment. This standard, which is defined separately for each segment of industry except agriculture, requires employers to provide employees with personal protective equipment designed to protect them against certain hazards and to ensure that employees have been effectively trained on the use of equipment. PPE. This equipment can range from protective helmets to prevent head injuries in construction, to eye protection, hearing protection, hard-toed shoes, special goggles for welders, and gauntlets for iron workers. Employers must generally provide required personal protective equipment to their employees free of charge. Employers must record work-related injuries and illnesses that result in death, days away from work, restricted work activity, or job transfers, medical treatment beyond first aid, and loss of consciousness. Retaliation. The EEO prohibits punishing job applicants or employees for asserting their rights to be free from employment discrimination, including harassment. Asserting these EEO rights is called protective activity and can take many forms. It is unlawful to retaliate against an employee. Refusing to follow orders that would result in discrimination, resisting sexual advances, or intervening to protect others. Participating in a complaint process is protected from retaliation under all circumstances. Forms of retaliation include reprimand the employee or give a performance evaluation that is lower than it should be, engage in verbal or physical abuse, demotion, increased scrutiny, make the person's work more difficult. Closing thoughts. Respect, listen, and communicate. Treat each employee with respect, educate them on workplace issues, educate them on the safety and proper use of equipment, educate on harassment and discrimination, Create an open door so the employee feels safe communicating issues and needs. Most important is listen. If you listen to those you are managing and treat them with respect, there will be less turnover, discord, and safety issues. Thank you for being a leader within our organization.